I think Oklahoma does, and there's a few others. But in North Carolina, your license is a PE, and the caveat is that you practice within your area of competence. And when the board looks at that, we're looking at your training, your education, and your experience. Of course, we look at other things as well. We'll look at, hey, what'd you take the exams in, and that kind of thing. I will tell you that in North Carolina, most of the licensees that practice structural engineering have not taken the structural exam. Most of the licensees in North Carolina that make application to take the structural exam are already licensed as PEs. And they're taking it because they want to practice in a state that requires it. So certainly there can be crossover in the disciplines. But if there's a question about your work, then you need to be able to show the board that, hey, here's how I got competent in this particular area. And just because you practice, for example, I keep using structural, but just because you practice in structural engineering, that's your area of competence. That doesn't necessarily mean you're competent in everything with structural. So certainly you have to exercise some professional judgment there as to where your limits are. All right. And then, of course, we do have lots of other rules we're going to talk about, one of which, and this is one we do see from time to time in complaints, where licensees are not being truthful, not being objective, not including all relevant and pertinent information in reports, statements, or testimony. So we do see that in complaints. There's another a requirement that you can't indiscriminately criticize another licensee. We don't get too many of these complaints. We've had a few over the years. But what's indiscriminate criticism? Sometimes you're hired for the very purpose of criticizing somebody else's work, and that's fine. A client can engage you to critique somebody else's work. It is criticism. But if you're going to criticize somebody else's work, even if it's something that you're hired to do, it needs to be truthful, has to be objective. You got to include all relevant and pertinent information within the criticism. So when we're talking indiscriminate criticism, it's really more of the malicious nature that we see that. And now I'm going to turn it over to Wes. He's going to talk a little bit about conflicts of interest, qualification-based selection, and then Dr. Gould is going to talk some on responsible charge and some of the other rules.
Good afternoon, everyone. My name is Wes Tripp, board counsel with the Engineers and Surveyors Board, and have been serving in that role since November of 2023. This is my second state construction conference, and happy to be here with you all to discuss an exciting topic, the rules of professional conduct. And we're going to start off with talking about conflicts of interest and avoiding them. So the first part of the rule related to conflicts of interest requires that you provide notification to folks, whether that be the employer, someone who you were subcontracted by, the client that you're working for, or any reviewing agency. The rule requires that you just provide notification of a potential for a conflict, or if a conflict exists. I've seen this situation a couple of times where engineers will reach out to me and they are providing engineering services on their own home. Now, while an engineer has a vested interest in making sure that the services that they're performing for their own home are high quality and good because it's the property they're going to be living in, there's still a potential for a conflict of interest. And I've told folks that, yes, you can provide engineering services for your own structure, for property you own. You just need to inform anyone that you're working with, inform reviewing agencies that there's a potential for a conflict, and then they can move forward how they see best. But just the requirement that you let folks know that there's a potential for a conflict of interest. Next, not accept compensation for more than one party for services on the same project without written agreement from both parties. And then that next bullet is very similar, not solicit or accept financial or other considerations for specifying material or equipment suppliers. And really, those last three bullets are kind of all related to the idea of we want to make sure that the work that you're doing, you're not being influenced by any side money, any side deals. So those are prohibitions in our rules. Continuing along with avoiding conflicts of interest, these points talk, at least the first two talk about instances where engineers are, maybe they're working or not working, but they're serving the public through sitting on city council, county commission, planning commission, any kind of public body that has review authority. Obviously, if you're sitting on city council or a planning commission and projects come before you that are from your firm, you need to recuse yourself. And then, for instance, if you're a member or if you're part of a firm and one of your principals is on city council and you're soliciting work, then you can't do that if the individual is sitting on that body. We had this instance, or a firm reached out to us where one of their owners and principals is about to be elected to city council, and this firm reached out to us to proactively to figure out what they needed to do, because this firm was one that does a lot of work for a city, and they wanted to continue to do that. So they reached out to us to make sure that they were following all the proper steps in making sure that they were complying with the rules in that area. So as David talked about earlier, very similar, you can only work in the area that you're competent in. We also require that you solicit work based on your area of competence, your qualifications. You can't offer to pay directly or indirectly any commission, contribution, gift, or other consideration to secure work, or also compete for work. Or you must compete for work based on your qualifications and competence. So if you're a structural engineer, you don't need to be advertising that you do any other kind of work unless you have gained competence in that area, either through CPC courses or other education courses in college, or through experience out in the field. So next, we're going to be talking about Minnie Brooks. This is a quote from one of our board rules that requires engineers to comply both with the federal and the state Brooks Acts when it concerns bidding on public projects. So North Carolina's Minnie Brooks Act is found in our General Statutes, Chapter 143-64.31, and it concerns the procurement of professional services, architectural, engineering, surveying service for units of government. So Minnie Brooks requires a qualifications-based selection, which is a procurement process that focuses on a firm's qualifications rather than the cost of the services that they're going to be provided. This process is often initiated when a municipality or unit of government issues a request for qualifications, seeking responses from interested firms to provide services. And it's not competitive bidding, as in the bid goes to the lowest bidder, but a bidding process focused on an engineering firm's qualifications. And this is the main quote from the statute. It's a public policy of this state and all of its subdivisions to announce all the requirements for these professional services and seek firms that are qualified based on their qualifications, not on how low the price of services that they can offer. So the act that applies to all units of government in the state of North Carolina, all from the state all the way down to municipalities. And there are exemptions in the act. The act does exempt projects that are less than $50,000. In that case, the RFQ qualifications-based selection process is not required, and a city, municipality, town can use whatever process they desire if the project is going to be less than 50K. Additional exemptions exist for projects under 500,000, and these are for projects, state capital improvement projects under the State Building Commission, projects at any of the UNC system schools, and also community college projects. So I'll often get requests from engineers, and I hear a lot requests from the folks over at ACEC about RFQs that get sent to us, and they ask me, does this comply with Minnie Brooks or not? And what I advise folks who reach out to me, the first step is to contact the municipality, contact the planning department or the county or city attorney, and get their explanation and justification for whether or not or why they think the RFQ either does or does not qualify under Minnie Brooks, and that usually should resolve the issue. Yeah, as I said, you can contact me and get my opinion. I've told folks, yeah, I think this isn't Minnie Brooks appropriate, but unfortunately, I can't then go tell a municipality. The board doesn't have the authority to tell a municipality what to do and say, hey, this RFQ violates Minnie Brooks. You need to change your process. But that rule that I showed up earlier on the screen if you believe an RFQ violates the act, then don't respond, because the rule prohibits a knowingly cooperating with a violation of the Mini Brooks Act. So further information on the act is available on our website. There is a copy of some PowerPoint slides that I provided at a presentation with ACEC last year that goes a lot more in depth into the Mini Brooks Act. So if you have any questions about that, you feel free to ask at the end of the presentation, and also refer to what's on our website. So next, I'm going to turn things over to Mr. Gould.
Good afternoon. My name is Vinny Goel. I'm the engineering board member and vice chair of the licensing board. And we'll talk about sorry. So, thank you. So I'm going to talk about the professional conduct item that I guess David and Wes were already talking about. So one of the first thing we'll talk about, professional services should be done always in ethical and lawful manners, and don't associate with dishonest or non-licensed individuals or firms. What you should do if you're aware of a violation, comply with all other jurisdictional rule requirements. Let's say if you are licensed in more than one state beside North Carolina, so you had to follow those guidelines too for whatever license state you are licensed in. And if you are committing any violation anywhere else, you need to report those to your home state or North Carolina licensing board, because that could be taken as a disciplinary action if you don't report. Exercise responsible charge over all professional work that you are conducting. Have direct control and supervision over work certified. Possess full professional knowledge of and control over work. Exercise authority to review, change, reject, or approve work in progress and final work through examination, evaluation, communication, and direct throughout the development of work. For example, if you're using artificial intelligence or some other Upwork, you need to make sure that you are fully aware of whatever is performed or it's in the report, because ultimately you are responsible for that work. The responsible charge also states that you should be personally aware of scope of work, its needs, parameters, limitations, and special requirements. You'll be capable of answering questions relevant to surveying or engineering decision made. Accept full responsibility of the work. Responsible charge states that you maintain the records, calculations, drawings, surveys, specifications, and other documents associated with the work. The burden of demonstrating responsible charge ultimately lies with you. Now we're talking about rules of conduct for advertising. The rule says that as a licensee, you will not make any exaggerated, misleading, deceptive, or false statement or claims about professional qualification, experience, or performance. That includes omitting facts necessary to keep statement from being misleading, making statement intended or likely to create unjustified expectation, making statement containing prediction of future success. With that, I will transfer back to David.
One thing you mentioned was one of these online sites called Upwork. There's several of these sites that freelancers are using for soliciting professional services. The board's recently had quite an uptick of complaints dealing with these sites. In fact, I just opened a case yesterday against a company that had advertised they were in seeking a North Carolina PE stamp on some structural calculations and design plans. That was all done. They didn't need to do anything other than sign and seal it. So they actually posted this on the website. And we've had numerous examples of our licensee seals being fraudulently used on this website by people that are advertising to provide basically services on the cheap, and unsuspecting public, or maybe suspecting public because they're trying to get it done cheaply, are going on there. They post the job, they make the connection, they pay whatever the cost is, and they've got sealed documents that are turned into the inspections departments. And where we've caught most of these is when the inspections departments have questions about the work, they'll contact the licensee by going to our website or contacting the board to get their contact information. And the licensee said, I have no idea what you're talking about. And then come to find out is they've taken their seal and they've applied it to work that's not theirs. So it's a real problem. It's a national problem. We talk about this on the national level. In fact, we just had a review committee last week where we had a number of these cases involving Upwork. I think Fiverr was another one. That Wes is going to be contacting the Consumer Protection Division of the AG's office to see if there's something that can be done at the state level. So it's a real problem you should be aware of. All right, I want to talk a little bit about certification requirements now. Anytime you see in the back of the news bulletin that somebody got in trouble for not properly certifying work, it's almost always a board-generated charge. Very rarely do we get a complaint where someone is saying, hey, this person's not properly signing and sealing their work. So you've probably seen the, licensees using a facsimile signature. Well, it's prohibited, but that's generally not part of the complaint. But if we get a complaint against the licensee, that licensee's practice is going to be under the microscope by the board. So whether it's a survey complaint or an engineering complaint, the board's not going to turn a blind eye to things that it sees wrong with work. So those are going to be basically add-on charges. That's not really the reason they're before the board, but nonetheless, it's a rule, so you got to follow the rules. So of course, as you all know, when you sign and seal work, that's letting the public know that in fact, it's your work prepared under your direct supervision. And Dr. Gould kind of covered, hey, here's the tenets of responsible charge, that you're competent in that area of engineering or surveying, and that the public can rely upon it. And you should understand that and be familiar with section 1103 paragraph C, which is the exceptions to required certification, where you can, where if it's not final work, you can mark it as progress drawings or preliminary for review purposes only and that kind of thing. And then in that case, certification is optional. So I do know that for review purposes, for most municipalities and agencies, if there's no signature and seal on it, they're not looking at it. So that's one of the reasons the board added the for review purposes only statement, so that knowing you're going to get review comments, that you've got the opportunity to add, make a revision to your work. And then of course you need to be competent in all areas of practice that you're certifying. So, and if you're not, or it's the work of more than one design professional, you can of course should both sign and seal the work and then delineate by way of a note under your seal what each is taking responsibility for. And I used the example earlier. It's probably one of the more egregious examples we had over the years. We had a firm in Charlotte, and it was a multidisciplinary firm. They offered most all the building disciplines, and the owner had engineers that were competent in all these areas. In fact, they were doing the work. But because it was his name on the shingle, he insisted on signing and sealing all the work, not the engineers that were actually doing the work and were competent. So nonetheless, we had a complaint filed, and we've since corrected that practice. But his mindset was, "Hey, it's my name on it. I'm signing and sealing it." But that is incorrect. You have to be competent in those areas. We talked about delineation, and then one thing I would like to just kind of point out, because we've had this happen before. Make sure your staff knows not to let your work leave your office unless you know about it and it's signed and sealed as final work product, or it's qualified in some form or fashion, because once it leaves your office, you have no control over it. So we've had situations where stuff's been submitted to the attorney to look over, to the architect, the contractor, the client to give some feedback, and then it ends up someplace you didn't intend for it to end up. So the point is, don't let it leave your office unless it's been certified or it's qualified in some form or fashion. What else to consider? So when it comes to the certification, that constitutes the seal, a handwritten signature, and date of signing. That's kind of the old school certification, right? I know a lot of firms now are using electronic certification. I've got a slide on that as well. We still continue to see a lot of facsimile signatures. That's akin to using a rubber stamp signature. It's not allowed. I know it's easy, but it's not allowed. Is that going to be a hanging offense from the board's perspective? Probably not. Would you get disciplined for it? Probably, if there's some other issue with the work. But a lot of times when we see that, it's really just an education thing that, hey, you're not supposed to be doing this. The licensees provide some assurances of future compliance, and we move on about our day. Certification requirements also require a complete address and a firm license number. That firm license number was added a number of years ago, and it was primarily for the regulators in the state as a way to easily alert them to, hey, you should be dealing with a licensed company if they have a number. If they don't have a firm license number, that should be a little bit of a red flag to at least look to see if the company's licensed to provide the services in the state. And I know there's a lot of regulators in the state that's part of their process, part of their review process is the person that signed and sealed the work currently licensed, and is the firm licensed? So that's part of their checks. And then we talk a little bit about electronic certification. I know some agencies, that's the only way they want it now. So if you're doing that kind of work, make sure that your whatever certification process you're using electronic complies with the board rule. This rule's been in place for over 20 years. I will tell you that the board has an ad hoc committee, and the board's been studying whether or not we need to change the electronic certification for 15 years. I think Willie Stewart was on an ad hoc committee 10, 15 years ago looking at this issue, but the board's pretty serious about really studying this to see, do we need to make changes, or is this okay as it is? And as part of that, they're also looking at, I know a lot of you work in BIM world, how do we certify models to comply with the certification requirements? So that is something the board is currently looking at. In fact, we're going on, some of that committee is going to be meeting with Charlotte Mecklenburg folks in April to talk about their processes, because we've heard, and I don't mean to single out Charlotte, but there's some municipalities that are requiring documents to be unlocked for them to review. So clearly that doesn't comply with the requirements, but if you want to do business in those areas, then you got to submit it that way. Otherwise, they're not going to accept it. So that's one of the things that we're looking at. Talk a little bit about some of the reporting requirements. These do vary by jurisdiction. So some states have like 60-day reporting requirements, some 90, some report this stuff at renewal. North Carolina, for the most part, if you're making changes to addresses, if it's a discipline or criminal conviction, change in resident professional, that kind of thing, ownership changes, 30 days. Some of this stuff you can do on your own. Of course, you can go to the website and make address changes anytime you want. But if you're disciplined or, God forbid, you're convicted of a crime, and, I thought all engineers were up here when it comes to that stuff, but believe it or not, every year we have licensees that are convicted of crimes. So we do look at that, at those issues. And then, for ownership requirements, North Carolina is, I think, is one of 5 states that has some version of a professional corporation act. So most of the companies that are licensed in North Carolina are licensed that way, either as professional corporation or professional limited liability company. So they have to meet the 2/3 ownership requirements. It doesn't necessarily have to be all engineers. It could be a multidiscipline firm. It could be engineers, architects, geologists, that kind of thing, surveyors. But it's got to meet the 2/3 ownership. There's certainly some workarounds. There's what we refer to as pre-69 corporations, where basically those corporations were set up prior to June of 1969 to provide engineering or surveying. And they can essentially offer any services. That's not restricted to just the professional service. Pretty valuable firms, by the way. And then a lot of times you see national firms, you may see they'll have of North Carolina PC after their names. Those are almost always companies that they set up specifically to do business here, because they don't meet the ownership requirements otherwise. So, but if you have questions about any kind of business compliance, business changes and that sort of thing, certainly Wes can answer those, but Mark Mazonik handles the business compliance and licensing for the board. So he's a good resource for you as well. I just want to touch briefly on moonlighting. The board doesn't regulate moonlighting activities, so that's between you and your employer. I know, and there's probably I'm sure there's some state employees here. We have had complaints before against licensees for doing work on the side. And it's not because they're doing work on the side, it's because what they're doing doesn't meet the standards. So if you're going to do work on the side, even if it's not being work that you're not being paid for, if you're doing a favor for your HOA, your church, your next door neighbor, it's still engineering work or it's still surveying work. It's got to meet the requirements. And if it doesn't, that's where people tend to get in trouble. And then, of course, if you have an office in North Carolina, you have to have a resident professional designated with the board for each profession. If it's if the company's located outside of North Carolina, then they have to have a responsible engineer or surveyor designated with the board. The board is looking at this rule, whether they need to tweak the resident professional requirement or not. I know, when COVID occurred, everybody's working remote, right? And a lot of that kind of stayed that way. So, is it possible to exercise responsible charge in your slippers and sweatpants, from home over somebody? Of course it is now. I know when I first started working for the board, kind of the mindset was if you're not under the same roof and you can't walk down the hall and tap them on the shoulder, you weren't in responsible charge. Well, of course, now everything's electronic, so it's much easier to do that, and in a lot of ways easier to go in, through VPNs and whatnot and see what people are doing. So, all right. And then I want to, we ran out of time last time for questions. I want to make sure we give a little bit of time for questions this go around. I want to talk a little bit about complaints. A couple of years ago, the General Assembly kind of pushed the licensing boards, not just our board, but all boards, to make the complaint process a little easier for the public. So one of the barriers was that we had a requirement that complaints had to be sworn to and notarized. So somebody would pen their complaint, they'd carry it to a notary public, they get it notarized, mail it in, all their documents and so forth. So we've eliminated that requirement. We'll accept complaints by email. In fact, most complaints come by email now, probably 95% of them. We don't accept anonymous complaints, so you still have to provide your name, contact information, all that good stuff. We do require that you submit some evidence to substantiate the complaint. If we determine charges, then of course we would want you to meet with the investigator to kind of detail the complaint further, particularly if it's a technical issue or ethical issue. And then if a matter goes to hearing, either before the board or the Office of Administrative Hearings, then you of course would need to be willing to testify. The board has very few hearings now. I would say probably one every 18 months. Our disciplinary process is such that we have what's called a settlement conference that affords a licensee that's got a notice of contemplated action the opportunity to come in, sit across the table. If they have an attorney, bring their attorney with them, with the committee members to try to resolve the matter short of a hearing. Hearings are very time consuming for all parties and they're very expensive. So if we can avoid that and achieve the same results through our settlement process, great. We've had that process in place since 1994. And prior to that time, the board used to have hearings at virtually every board meeting. They would have hearings on actions where licensees were wanting to contest a recommendation. You should know that our statute is such that our investigations are confidential, whether it's against a licensee or non-licensee. It's been we've had the confidentiality provision against licensee cases for a number of years. We just added non-licensees within the last probably 4 or 5 years. And we did that because we had a lot of companion cases where we might have a case against an engineer and a non-licensed company. So it was kind of mixed. Some was confidential, some was not. So it became a little bit of a logistical issue to keep everything confidential with the non-licensed entity if they were requesting information from us. So we changed the statute. So now they're all confidential. If a case is closed with no action, it stays confidential. It's not like the Better Business Bureau, so somebody can't contact the board to find out, hey, how many complaints has this licensee had? We only report final actions. And if it's an action of the board, it's going to be on the website under violation lookup. All of our actions are public record, goes in the newsletter. It goes on the enforcement database that NCAAS maintains. And of course, all of you know NCAAS because you took the fundamentals and principles and practice exams. But the National Council does more than that. It develops model law, model rules. It maintains an enforcement database and the like. So I should also point out under the rules of professional conduct that you as licensees actually have an obligation to essentially file a complaint if you're aware of violations. In the time I've worked for the board, I've never known a licensee to actually be charged with this, but it's in the rules. You should know it. In fact, sometimes licensees will cite this rule when they pen a complaint. They'll say, hey, as required by this rule, I'm furnishing this complaint. I would ask, use some professional judgment. Sometimes just a little educating somebody can go a long way and resolve the issue. hey, somebody's not properly certifying work, point them to the rules. Company's not properly licensed, hey, contact Mark Mazzonic. He can get you squared away, get in your application and get it taken care of. So a lot of things can be resolved short of filing a complaint. The exception I would say is that if you are privy to something where you feel like the public is in jeopardy in some form or fashion and you do nothing, then obviously that's a problem. You're a licensed professional, you have this obligation, and you shouldn't turn a blind eye to something where the public could be harmed. And then I'll add, we also have a statutory provision that requires all of our licensees to cooperate with the board during investigations. And I can tell you that there's no quicker way for a licensee to lose their license than not cooperate during an investigation. And kind of the board's mindset is that, hey, if we're investigating you and you're not cooperating with us, then you're not subjecting yourself to the authority of the board. So therefore, we can't regulate you. And in fact, we're going to suspend or revoke your license because you're not allowing us to do that. I will tell you that at any given time, the board has a case in the state court system on appeal. So that's the process. We have a investigation, a review committee, a settlement conference. If it goes to hearing and the licensee doesn't like the outcome, their option is appeal it to Superior Court. It's appealed on the record. If they don't like the outcome in Superior Court, Court of Appeals, Supreme Court. And like I said, I've been with the board over 27 years, and at any given time we got a case in the state court system, the board has always prevailed. That's a great track record. And it's been the same prosecuting attorney for the most part too for that entire time. So the point is, and what should give you some solace, is that the board gives its licensees due process. If they're under investigation, they have their due process. We operate within the authority that the General Assembly has given us. We operate within our rules. I will also add that the standard of proof for administrative cases in North Carolina is the preponderance of evidence. It's a pretty low standard. More likely than not. It's not like on TV, beyond a reasonable doubt. So it's from a legal standpoint, it's a pretty low standard. But in my opinion, the board has always applied a higher standard than is it more likely than not that somebody's committed a violation before they take an action. And then, of course, we have certain processes that we follow for licensees versus non-licensees. The board's authority only extends to our licensees. 20 to 25% of our cases every year is dealing with non-licensed practice. So we have other ways that we deal with that. With the licensees, I've got on the screen here kind of the range of disciplinary actions that the board has to work with. I will tell you that I've worked with lots of different board members over the years. And for the most part, I feel like the board's position on enforcement is, what is it going to take to get compliance and assurances of future compliance? That's kind of the board's kind of thought process when it comes to discipline. If we can achieve compliance with a reprimand, and that's, a reprimand kind of case, then so be it. If we feel like we need education, and a lot of times we see that that's the case, maybe somebody needs some ethics education or they need some technical education, then we'll do that as well. We added that as an option a few years back. It used to be if you saw somebody was going to take an ethics course as part of a discipline, that was by way of settlement, but now we can impose education. And then obviously the most egregious examples that we see, we're looking at suspensions, restrictions of practice, and revocation of license. Typically when we suspend a license, it's not less than 6 months and not more than 2 years. And kind of like if the thought is if it's something that we need to suspend for more than 2 years, then we really need to probably just revoke the license. For non-licensees, a lot of times we get compliance voluntarily from these companies and individuals. If it's appropriate, we can close a case based upon corrective action. We can, maybe the company got licensed. Maybe they've updated their website to take some of the offending language off the website. It's, the practice of engineering or whatever. Sometimes we see some really egregious stuff where someone's fabricated or they fraudulently used somebody else's engineering credentials. We've had people make up engineer seals, take somebody's number, they got their name on it, and they went into business. So, they're beyond kind of sending them the letter sort of thing. So in those cases, we'll have our investigator go to the magistrate, swear out criminal charges. Practicing engineering or surveying without a license is a misdemeanor. not a real exciting thing for the district attorneys. But if we have victims where they have, taken thousands and thousands of dollars from the unsuspecting public and rendering services they're not legally entitled to render, then it's a fraud. So they get a little more excited about the fraud than they do the practicing without a license. Since Wes has been with the board, we started making more use of injunctions. So it's a civil action where for non-licensed individuals and companies, he'll go to Superior Court and file for injunction. And I believe all the ones that he's filed since he started for the board, we've been granted. I don't think any of them have been contested. Yeah, so we've been granted all of those injunctions. So that gives the board a little more teeth. So if you read in the newsletter that the board got an injunction against somebody for practicing engineering without a license, and we see that same person again or same company again, then we can bring them back to court and it's contempt of court. So now there's some teeth there. There's some authority of the courts to take a greater action than the board can do. And then, of course, we have relationships and some agreements with some of the licensing boards in the state. So sometimes we'll get complaints against architects or geologists, general contractors and the like for practicing engineering without a license. So the board will do their investigation, will make the determination, okay, they're in fact practicing engineering. And certainly if it's deficient work, we want to detail that as well. And then we send it to their licensing board because they have the authority to take the action. We do not. And same thing, with those other boards, they may investigate an engineer for practicing those professions. There's certainly some overlap in some of the professions, but they can refer them to our board and then our board can take whatever appropriate action. When you read about a discipline in the newsletter, please understand that each case is looked at individually. Although we do have some historical perspective. Andrew Ritter, the director, and I have been there a long time. We've literally been involved in thousands of cases for the board. So we have a little bit of historical perspective on how the board's looked at things over the years. But we look at, hey, what are the circumstances here? What was the nature of the violations? Was there harm to the public? What was the potential for harm to the public? Certainly ethical transgressions and competency cases and responsible charge cases, those are going to be more serious than somebody using a facsimile signature, right? CPC cases, for example, if the board's, if you're one of those lucky few that's been audited and the board finds that you didn't have what you said you had, and you don't have the hours made up by the time this thing gets to review committee, you're probably going to get a suspended license for not complying with the CPC requirements. So that's another quick way to lose your license. And we talked a little bit about cooperation already. I will tell you that a lot of the review process, I think in large part works in the state, whether it's at the state level or local level, because a lot of things are caught before construction and referred to the board. So the board will have to look at, okay, this thing wasn't actually permitted, it wasn't actually built, but the potential for harm was, what there was built is really there. Maybe we got a case where somebody's not in responsible charge or they're not competent in this area, what have you. So we will look at all of that. So why discipline? I will tell you the board takes it pretty seriously if they're going to take an action against a licensee. It's a pretty heavy thing. Certainly if you violate the board rules, it's misconduct just in and of itself. So the board in that regard can take the disciplinary action. So certainly there's some punishment there. But the big thing is when we take an action, in large part, it's because we don't want to see that licensee again in front of the board. We're not always successful in that regard. But we also want it to be a deterrent to other licensees because nobody wants to end up in the news bulletin. Education is an important thing. If we see that's really what's lacking there. Somebody needs additional education in the area. That's what we're going to pursue. Corrective action and compliance. The board has a lot of discretion when it comes to discipline. So someone can commit a violation, and if they fixed it, they provided adequate assurances to the board that we're not going to see this kind of thing again. The board has the discretion to close a case. That doesn't necessarily mean they will, but they can. And how somebody responds in a disciplinary case, in large part, determines penalty. So, if somebody's done wrong and they dig their heels in, then the board's going to take a heavier hand. If somebody's done wrong, recognizes it, provided some assurances of future compliance, maybe they fixed something, whatever, then the board can certainly factor that in. It's a mitigating circumstance that we take into account. We do publish all the discipline, as I mentioned, newsletter, enforcement exchange, the National Enforcement Exchange. You do have to, all the states have reporting requirements. If we find out about it and it's not been reported, or somebody's attested on their license renewal, hey, I haven't been in trouble since I last renewed, and we find out otherwise, that's going to be a problem for that licensee. Just talk briefly about caseload last year. Let me just add, most licensees do the right thing every single day, year in and year out for their whole 35, 40-year or plus career. Their only involvement with the board is when they make application, renew their license, and maybe you get audited your CPC every so often. That's it for most people's entire career. We do deal with a small segment of the licensed population. Of course, not every complaint that comes in is a valid complaint. We know that. In fact, I would say on average, on the engineering side, probably 40 to 50% of our complaints result in some kind of discipline, and the rest are closed in some form or fashion. I'll point out, surveyors have always made up a disproportionate number of our cases, and I think that's in large part due to the nature of what surveyors do. And they tend to deal with the general public more so than engineers do. So we do have our repeat offenders, frequent flyers, whatever you want to call them. And this, I'd like to say last year was kind of an outlier. It's not. It's like that. It's like this every single year. So last year we opened 148 cases. 44 of those respondents had 83 prior cases. So if Wes and I know somebody's name, they either served on the board or they've been in trouble with us before. That's not a good thing. But like I said, not every complaint is a valid complaint. We know that, but still 25 of these respondents had been disciplined previously. And I think most people here are probably engineers. So probably interested, where are the engineering cases coming from? Relatively small percentage of the engineering cases come from what I consider to be the general public. Certainly, if you work in the public sector where you're dealing with individual homeowners, I think you're much more apt to end up in front of the board than if you work for government or, contractors and that kind of thing, because you have other ways to work out your issues short of coming to the board. I will tell you, a homeowner who doesn't like what you did has no problem turning somebody into the licensing board. So that's why we see a lot of that on the surveying side. The board also opens cases, and most of the cases the board opens against engineers are for licensees being disciplined in other states. And it's usually revocations, suspensions, and restrictions of practice. If South Carolina gave somebody a reprimand and $1,000 civil penalty or whatever it was, as long as that's reported to us, then so be it. We make note of it and move on. Some states will pile on discipline. We have the authority to do that. Most states do. We just choose not to. On the surveying side of things, it's almost always going to be the surveyor's client or the next door neighbor. They're not happy about something. So probably I would say 75 to 85% of our cases every year on the surveying side, they're coming from what I consider to be the general public. And I think I did a little better than last time. So I'll open it up. I think we got just maybe 2 minutes or so for questions. And if you want, if you don't want to ask it in front of us, in front of the group here, you can email Wes or I, and we'll be glad to try to answer your questions for you. So if there's any questions, I think we got like 2 minutes. End of the day, right? All right. Well, thank you.